Members, it's the appointed time. This is the meeting of the Bills Committee on Rating Amendment Bill 2024. I call to order the meeting. I may first invite government representatives to join us. We have Mr. Maurice Liu, Deputy Secretary for Financial Services and the Treasury. Mr. Stephen Low, Principal Assistant Secretary for Financial Services and the Treasury. Mr. Kevin Siu, Commissioner of Rating and Valuation. Ms. Wendy Tang, Assistant Commissioner, Rating and Valuation, as well as Mr. Anderson Chen, Senior Government Counsel. In the last meeting, we stopped at Clause 7, Section 3.2, the schedule. We also covered the definition of domestic tenements. The legal advisor wrote to the administration, please refer to LC paper number CB bracket 1X85/2024 bracket 01, as well as the administration's reply to the legal advisor. Perhaps I'll first invite the administration to walk us through the reply. Thank you, Chairman. Sorry, Chairman. All right. I'll first talk about the legal advisor's questions. The first question on how we define domestic purpose. The legal advisor asked whether it is necessary to clarify the definition of domestic purposes and whether we should refer to other ordinances or legislations in terms of the definition. We've looked at the relevant suggestions. Currently, RVD, based on the occupation permit of the relevant tenement, the mode and character of the occupation of a property in determining whether it is a domestic or non-domestic tenement. RVD also will consider any relevant specified instrument, for instance, government grant, deed of mutual covenant, occupation permit, or building plan. Generally speaking, premises wholly or primarily used for domestic purposes will be classified as a domestic tenement. We think that the current practice can cover most of the circumstances that may arise, and we think it's not really necessary to have a definition for domestic purpose under the bill. The legal advisor gave a very good suggestion. That is whether we would refer to the definitions of domestic purposes in other ordinances. We've looked at those definitions and we think that those definitions may not apply to this bill. For instance, under the Waterworks Ordinance, the definition of domestic purposes is about premises wholly or primarily used for domestic purposes. And garden, playground, or swimming pool may not be taken into consideration. For RVD, however, we do consider any gardens, playgrounds, or swimming pools, for instance, as we define a domestic tenement. We think that the definitions provided in other ordinances are not very applicable to this bill, and we think that it's not very necessary for us to have a definition of domestic purposes for this bill because the current practice can cover most of the situations. Yes, Commissioner. The second question is about how we define a tenement is mainly for domestic purposes. As mentioned by the Deputy Secretary, we take into account a series of considerations and factors. Say a premises is put to a mixed use. When we decide whether the premises is wholly or primarily used for domestic purposes, say, for instance, an owner or occupier of the premises is using the premises intermittently for other purposes, still we would consider it as a domestic tenement. On whether there is an appeal mechanism or a classification mechanism, we have an effective mechanism that has been put in place. If there is a change in terms of the use of the tenement, and the owner or the occupier may ask RVD to review the classification, we will conduct site inspection, we will consider the relevant instruments provided, and all other circumstances to review the mode and character of occupation of the premises concerned to decide whether the premises should be classified as a domestic or non-domestic tenement. We'll also explain to the relevant parties about the review result. If the relevant party is not happy with the review result, we will review the objection in accordance with the established procedures. Currently, there is an objection handling mechanism. Over the past few years, we have handled a number of such cases, and it shows that the mechanism has been effective. Deputy Secretary, the fourth question from the legal advisor concerns the proposed new Section 3B to the proposed new schedule of the bill. That is whether a parking space which according to its nature is not available for rent by the public for any duration would constitute a domestic tenement, and whether a parking space which is being rented out would be exempted from the new rating system. We consider whether there are residents or occupants of domestic units or their bona fide guests, visitors, or invitees. And if they are using the parking space concerned, then the parking space would be considered as domestic tenement, while fee-paying car park for public use should not be considered as a domestic tenement. Paragraph 3B1 of the schedule sets out clearly the circumstances under which one or more parking spaces will be considered as a domestic tenement. The paragraph aims to cover circumstances where the parking space is used by the owner or occupier of a domestic tenement or by any other person as authorized by the owner or occupier. Apart from the owner, occupier, or the authorized persons, the parking space shall not be used by members of the public. Certain government grants or deeds of mutual covenants have restricted the use of the parking spaces to the residents or occupants of the domestic units within the building or their bona fide guests, visitors, or the invitees. And these parking spaces are not allowed to be used by members of the public. These parking spaces are not permitted to be used as fee-paying parking spaces for public use. We think that the way the bill is drafted accurately reflects the policy intent. On the written reply provided by the government, I believe the legal advisor has some follow-up questions. Legal advisor. Thank you, Chairman. I have some follow-up questions. In my letter to the administration, that is LC paper number CB bracket 1865/2024 bracket 01, in question 2, it states that in relation to the Commissioner's proposed power to make a determination or decision concerning whether a tenement is a domestic tenement, please clarify whether a person could object to or appeal against such determination or decision. In LC paper number CB bracket 1890/2024 bracket 01, according to the administration, there is an appeal mechanism in place. Can the administration clarify whether this is a regular mechanism? That is, the mechanism will be in place on a regular basis. Well, as mentioned, this mechanism will be in use continuously. Well, if there are no particular views to the administration's reply, let's carry on with the clause-by-clause scrutiny. We stopped at clause 7. We should start from section 4 to the schedule. Yes, Principal Assistant Secretary. Section 4 to the schedule provides for some definitions. First, on religious institutions. Religious institution means an institution that owns or occupies a tenement that is used wholly or mainly for the purpose of public religious worship. The next definition is a specified instrument. The administration has to refer to certain specified instrument when making a decision. A specified instrument means a government grant, a deed of mutual covenant, an occupation permit, and a building plan. Specified school. They are exempted from the rating system, and a specified school means a registered school within the meaning of the Education Ordinance. That is not an exempted school as defined by Section 2 of the Education Exemption Private Schools Offering Non-Formal Curriculum Order, and is not operated for profit. Government grant. This definition is made in reference to the rating ordinance. Yes, Mr. Michael Lee. For specified school, it says it is not operated for profit. Does it cover private schools? Private school is included as specified schools. Well, you have and between point A and B here. Well, there are private schools that are operated for profit and not operated for profit. Right. So for private schools that are not operated for profit, they are specified schools, right? Correct. Certificate of registration. It has the meaning given by Section 3, bracket 1 of the Education Ordinance. For exempted school dormitories, they have to be included as dormitories with the certificate of registration. Yes, Ms. Doreen Kong.
Chairman, specified instrument is important because this is considered by the Commissioner in determining domestic or non-domestic tenements. There are 4 items there. I'm here to assist. Under specified instrument, would tenancy agreement be included? I'm trying to think. You have the government grant, the deed of mutual covenant, and building plan. The building plan may not be in sufficient detail. In the government grant, it may be domestic or non-domestic. Or the DMC for the old buildings may not be in sufficient detail either. Will the administration consider tenancy agreement under specified instrument? Chairman, the Commissioner will not just consider the specified instrument, but also the other documents. I'm sure that the document referred to would be considered. Commissioner, yes, Chairman, we will consider in a comprehensive manner. If necessary, we would have regard to the tenancy agreement as well. Normally, these four types of specified instruments would cover the majority of the situations. But definitely we will have regard to the document referred to, i.e. tenancy agreement. Ms. Kong, thank you. Thank you for the response. Point number 3 says that the Commissioner will have regard to the overall situation, including all the relevant documents, including the tenancy agreement. Is that right? That's correct. Yes. Thank you, Ms. Kong. Please carry on. Clause 8. Clause 8 is to exclude the Chinese medicine hospital. So Clause 8 would, upon the commissioning of the Chinese medicine hospital, the FSTB will publish this by a notice in the Gazette. Thank you. Thanks very much. Any further comments? Mr. Lee Chan-kung? Chairman, thank you. We're done with the scrutiny of this bill. Now, I've got 2 questions, though. Should we include a provision like the Section 88 institutions, the dormitories, can they be excluded? Now, with this mechanism, in the northern metropolis, for instance, there may be some dormitories, or indeed in other areas, this can be exempted. I don't see anywhere any mention of this mechanism in the bill. And I think that this bill is inadequate. But there are exemptions there, so you are saying that they can apply for exemption, right? Chairman, we carve out certain institutions because of the evaluation of the Commissioner. We do not rule out a similar situation in future. And we have to make it clear in the bill, in future, if there are any changes, I think it would be best for amendments to be made via Let's Go, and we will be soliciting members' views. Why don't we consider letting the public have the right to seek exemption? If you designate domestic tenements, you are really putting yourself into a straitjacket. Chairman, when we consider the exemption, we have already taken into account the types of exemptions that would be needed and whether there is a good enough justifications for the exemption before we put this in. Now, we have included all the institutions that we consider should be exempted, but if a new scenario arises, which we do not anticipate now, it would be right and proper for us to seek amendment to the ordinance, because I don't think we should be taking any decision in a rash manner. Mr. Kong? By mistake, sorry, Chairman. We're done with the Chinese version. Members and legal advisor, what about the English version? Are there any comments or any supplements? Legal advisor, the two versions are consistent. Right, my thanks to the officials and members. We're done with the scrutiny of the bill. Would members make any amendments? Mr. Long, Chairman, I'm not suggesting that I'm going to be moving any CSAs. I'm just saying that we are done with the clause-by-clause scrutiny of the bill. What's going to happen next? We will be collecting public views up until the 1st of July. Are we going to be looking at the submissions, or do we see the merit of one more meeting to follow up on the submissions? Let me say this first. The deadline is 1st of July. We have received so far one submission, and we'll refer this to the administration for their comments, and we'll allow them sufficient time to make a response. We have several options. Either we have one more meeting, or if we don't have a lot of submissions, we can have the submissions circulated to members. As of now, we have received only one submission, and I think we can adopt the latter option as a way forward. I defer to the administration. Chairman, yes, whatever submissions members receive, we are prepared to give a written response so that members would be able to have the administration's response circulated, and to tie in with the chairman's suggestion, we can have the response circulated to members. Mr. Long? Chairman, if this is the standard practice, I have no quibble over that, but I'd just like to reserve the right that if members have read the administration's responses, and if there are things that we need follow up, perhaps we might need to convene one more meeting and invite the administration for some elucidation. Now, I suggest this because we don't really want to deprive the administration of the opportunity to explain themselves. And I hope that this Bills Committee will not give up on any opportunity to follow up on the issues that are outstanding, that they're not sufficiently clear. I'm speaking for myself because this is not taking the people's right and members' right to move amendments. Yes, indeed. I'll circulate the response to members, and depending on what members have to say, I will decide on the next step. Members can rest assured that your views will certainly be considered. Well, let's hear from the administration about the legislative timetable. We seek this resumption of second reading debate on the 17th of July, right? There you are, July 17th, second reading debate. Any comments? If not, we will proceed accordingly. We're looking at this date, 17th of July. We'll have to report to the House on the 5th of July. So please take note of the dates. For amendments, the deadline for notification will be no later than the 8th of July. We will keep an eye on the submissions that are forthcoming. We will circulate them to members in the first instance. Any other business? All right. Unless you have any other business, meeting is now adjourned. Like Mr. Long said, should we see the merit of any further meeting, the Secretariat will so notify members. Our meeting is now adjourned. Thank you all very much.